अंगी साहब अस्सलाम वालेकुम, आपकी अपने माइक ऑन कर लें प्लीज। क्या हाल है आपका मंगी साहब? गुड टू सी यू। Okay.
Yes, ma'am. How are you? I think there was.
Good. I can hear you well and good.
Yes, yes. So from my side, mic was on, but some systematic problem was there.
Now it's good to hear your voice. It's an important voice to be heard.
Oh, no.
I'd like to welcome the rest of the panelists. Can everybody hear me? Mr. Rodriguez, can you hear me?
Yes, I can hear you.
Ah, wonderful. Okay. I'm just waiting for a go ahead from our team. Hi, Nicole. Mr. Rodriguez, do you have your camera on?
Hi, Sarah.
Hi, Nicole.
Hello, good to see you.
I know, it's good to see you too. Okay.
How are you doing?
We're good. I just want to highlight to the panelists that most of our viewers are on Facebook. So this is being streamed live on Facebook as well. So don't get discouraged by the numbers you see here.
Very good.
Thank you so much. We're live now, so I'm going to begin. Okay, good afternoon. My name is Sara Bilal, and I am the Executive Director of Justice Project Pakistan. We're an organization that represents the poorest Pakistani prisoners facing the harshest punishments at home and abroad, which includes prisoners facing the death penalty, prisoners who are mentally ill, juvenile offenders, and victims of torture by the police. We are here today to celebrate the virtual launch of a joint report by JPP and OMCT, which is the World Organization Against Torture. This report is titled Criminalizing Torture in Pakistan, the Need for an Effective Legal Framework. The World Organization Against Torture, which is OMCT, is the main coalition of international non-governmental organizations fighting against torture, summary executions, enforced disappearances, and all other cruel, inhuman, or degrading treatment. With over 200 affiliated organizations in its SOS Torture Network and many tens of thousands of correspondents in every country, OMCT is the most important network of NGOs working for the protection and the promotion of human rights in the world. So today, I'd like to welcome everybody and thank them for joining us today. Before we begin this before we begin the webinar, I'd like to just set out the agenda for you and also some of the structural points on what we're going to be doing today. So we'll start with a brief introduction to the report that will be given by myself and Nicole from OMCT, and it's going to be followed by a panel discussion in which our esteemed panelists will examine the need for an effective legal framework criminalizing torture, and also taking stock of the progress that Pakistan has made since signing the Convention Against Torture in terms of complying with the convention. And then this will be followed by a Q&A session at the end, and the audience will have an opportunity to ask questions of our panelists. So let me get down to introducing the panelists. It's my honor and pleasure to introduce Mr. Diego Rodriguez Pinzon, who's a member of the UN Committee Against Torture, which is the body of 10 independent experts that monitors implementation of the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment by the state parties. Mr. Rodriguez is the co-director of the Academy on Human Rights and Humanitarian Law, co-director of the LLM in International Human Rights Law and Humanitarian Law, and full-time faculty at the American University, Washington College of Law, Washington, D.C. Welcome, Mr. Diego. Secondly, we have Senator Faratullah Babar. It's a person that needs no introduction in Pakistan, but he is the Secretary General of the Pakistan People's Party, the opposition party. Senator Babar has remained a member of the Senate of Pakistan for 2 terms, from 2003 to 2006, and from 2012 to 2018. Senator Babar has played a seminal role in Pakistan's journey towards criminalizing torture. He moved the first ever torture custodial death and custodial rape prevention and punishment bill in 2014 in the Senate of Pakistan, which was actually passed by the Senate in March 2015. Welcome, Senator Babar. Finally, last but not least at all, we have Mr. Mohammad Hassan Mangi. He is the DG International Cooperation of the Ministry of Human Rights. I would say that he's one of the most experienced bureaucrats that we have at this time in Pakistan. He has been working with the Ministry of Human Rights in this capacity since 2001, and he continues to serve out that role today. Being a member of Pakistan's delegation, he presented and defended Pakistan's 5th periodic report on the implementation of the UN Convention on the Rights of the Child in front of the UNCRC committee. He has also assisted the Ministry of Human Rights in the implementation of the 7 core human rights conventions and covenants in Pakistan. Welcome to the webinar, Mr. Mangi.
Thank you, ma'am. Thank you. And in addition, I was the one who also participated and submitted the Pakistan's report on CATE to the committee.
Oh, wonderful. So Mr. Mangi also submitted the CAT report. Great. Now we're just going to go through a very quick introduction of the report by OMCT and JPP. But because we want to get to the panel, and I know Mr. Rodriguez has to go because we messed up on daylight savings time. So thank you so much for your patience, sir. So torture by the police and law enforcement agencies in Pakistan is unfortunately a systemic problem. Because it is a widely common practice, it's accepted as an inevitable part of law enforcement in Pakistan. And perpetrators of torture are granted immunity. You know, you're going to have to excuse me, but I have 2 children who are at home, and you'll have to excuse the noise that comes from the back. And in case they burst forward, Nicole, you're going to have to finish the introduction while I shoo them away. But getting back to torture. So torture is accepted as an inevitable part of law enforcement in Pakistan, and unfortunately, the perpetrators of torture are granted immunity through a combination of a lack of independent oversight and investigative mechanisms, also wide powers of arrest and detention. There's also procedural loopholes and ineffective safeguards, which can all be greatly rectified if, as a country, we were able to pass legislation that criminalizes torture so we can hold people to account and shift the paradigm of what it means to, you know, what effective policing looks like and what accountability to the citizens is owed by the government. It's just important before I hand it over to Nicole to mention that the government of Pakistan ratified the United Nations Convention Against Torture, which we call UNCAT, in 2010, which makes it legally binding for us to criminalize torture. We also saw in February 2016, the National Action Plan for Human Rights, which was introduced by the Federal Ministry of Human Rights, setting a 6-month deadline to pass the bill to criminalize torture. However, unfortunately, despite these developments, the country is still trying to pass a bill or any comprehensive legislation that would effectively, criminalize torture by public officials. This joint report by OMCT and JPP looks at that journey, looks at the journey of this country since we signed the convention to pass a bill. This journey is not complete. I'd also like to point out that in true JPP fashion, this is not an indictment of any government, past or present. This is an opportunity to discuss with the experts, global and local, domestic, on taking stock of how far we've come and what the road ahead and the future looks like. And perhaps there's lessons we can learn from the past, and perhaps there are lessons we can learn from other countries to get on the road to actually fully complying. So with that, I would like to hand it over to Nicole. If there are things you want to add, Nicole, before we move on to the panel.
Thank you very much, Sarah. We're very happy to co-host this webinar and to have co-written this report. Of course, with this event and the report, we want to advocate for the enactment of anti-torture legislation in Pakistan. And our report actually highlights the development of Pakistan in criminalizing torture since it ratified the CAT Convention and the International Covenant on Civil and Political Rights. And I'm very pleased that we have a CAT committee member with us in the panel today who will talk about the CAT's requirement when it comes to criminalizing torture. Despite the importance of anti-torture legislation, many countries do not have specific provisions. Actually, in Asia, there are only 3 countries that have comprehensive anti-torture laws. And we really hope that Pakistan will become the 4th country in the region. We think this could also have a very positive effect on other countries, on other neighboring countries. And we've seen in other countries that only after enactment of relevant laws have there been people convicted of tortures. All countries have laws criminalizing bodily harm in one way or another, but those provisions are simply not used to prosecute torture perpetrators. Of course, an anti-torture law is no guarantee as such that there is, and there's a lot more that needs to be done to really eradicate torture. But a relevant law would be an important first step. And Pakistan will have to submit its 2nd periodic report to the Committee Against Torture this May. And an anti-torture legislation would be a very positive development, a very big milestone. Thank you very much, Sarah. I stop here.
Thank you, Nicole. I realized that I failed to properly introduce the only other woman on the panel. So I apologize to that. Dr. Nicole Burley is a human rights advisor and Asia coordinator for the World Organization Against Torture. And thank you, Nicole, for your patience, and thank you for letting me introduce you. Now, we are going to go to Mr. Diego Rodriguez, who's going to begin the panel discussion and give a brief presentation as a member of the CAT committee on the implementation of CAT and its implications for Pakistan. Mr. Rodriguez Pinzon.
Thank you very much, Nicole. And again, first of all, I might do a disclaimer that I must indicate that I'm not speaking on behalf of the UN Committee Against Torture, but in my academic personal capacity. I want to thank, of course, the invitation from the World Organization Against Torture and the Justice Project Pakistan to this event. Delighted, of course, to join the distinguished panel of speakers to discuss with officials, distinguished honorary dignitaries, other important actors, the subject that brings us today here. Let me first say that it's an important exercise that we consider in my law school crucial for the promotion and protection of human rights. It is indeed part of what we do in formal or informal teaching settings, such as you mentioned, the Masters on Human Rights and the Program of Advanced Study in our university. It's a joint endeavor that should bring together vital forces of our societies, from government officials to executive, legislative, and judicial branches, to civil society organizations, academics, and citizens interested in contributing and improve our democracies. Let's quickly move into our subject matter. In this presentation, I will make a brief explanation signaling some of the most notable aspects governed by the United Nations Convention Against Torture. But before I begin, I want to commend the efforts underway by the government authorities of Pakistan to implement the required legislation under the convention. The anti-torture legal framework has a dual dimension. First, it is a treaty obligation to implement such normative structure. And second, it's a necessary pre-requirement to be able to comply with all the obligations contained in the convention. In general, state parties to the convention have agreed to confront any form of torture by, among others, making it a crime, investigating and prosecuting allegations of torture, providing redress to victims, excluding statements acquired through torture from all proceedings, and taking legislative and other measures to prevent torture in general. Therefore, an essential task that states undertake is to constantly analyze their domestic legal frameworks to determine whether these norms meet its international obligations under the convention and consequently adopt new laws or amend existing ones. One first aspect under the convention is the obligation to implement national legislation, in the legislation, a definition of torture that adequately reflects all the elements contained in the definition stated in Article 1 of the Convention. This is mainly reflected in the criminal legislation of the state, considering that Article 4 of the Convention requires that every state party shall ensure that all acts of torture are offenses under its criminal law, which necessarily implies the obligation to criminalize torture as a specific crime, separate from other types of criminal offenses in its penal legislation. The elements contained in Article 1 definition that need to be reflected in the domestic definition of torture are, of course, the four main ones that we know. It refers to severe pain and suffering, intentionally inflicted for specific purposes that include, among others, discrimination, which is extremely important, and that they are inflicted by or instigated of or with the consent or acquiescence of public officials or other persons acting in an official capacity. Very, very important. Article 1 also indicates that such definition does not include pain and suffering arising only from lawful sanctions. It must be mentioned, however, that corporal punishment does not fall within the scope of lawful sanctions in this provision of the convention, and therefore fall within the definition of torture or ill treatment. It is necessary also to emphasize that Article 1 includes abuse committed by non-state actors if public officials knew or should have known that acts of torture were being committed by such private actors and they failed to exercise due diligence to prevent, investigate, prosecute, and punish perpetrators. In these situations, that the officials should be considered as co-authors, complicit, or otherwise responsible for consenting to or acquiescing for those acts. Examples of such obligation under the convention include the duty to confront violence against women or the so-called honor killings, as well as violence against vulnerable groups, including religious minority communities. The importance of adopting the definition of the convention in the terms mentioned before relies on several considerations of a legal and practical nature. First of all, it allows the state to adequately respond to its international obligations by being able to pursue criminal action against perpetrators of torture. It also allows the state to monitor the behavior of state officials and determine if the requirements of the convention are being implemented in practice and take any corrective actions that may be necessary. Furthermore, it allows the state to collect specific information about the occurrence of events of torture and how its administrative and judicial proceedings were carried out and allows the government to follow up on how victims of these heinous actions were able to receive adequate redress. All this information, in turn, is crucial to be able to periodically report nationally and internationally about the measures adopted to confront torture and its outcomes, its qualitative and quantitative information to support such reports. Without a clear and autonomous domestic definition of torture of Article 1 Convention, the efforts of the state to confront torture, monitor, evaluate, implement corrective action, as well as adequately report will lack a crucial tool. This is directly related to the need to ensure adequate data collection. Disaggregated data allows the state and the committee to effectively assess the implementation of the convention at the national level. For example, it is essential to collect data on complaints, investigations, prosecutions, and convictions related to acts of torture and ill treatment, including physical and sexual violence against refugees, girls and women, persons deprived of liberty, among others. Another aspect that is important under the convention is the requirement by the state parties to affirm the absolute prohibition of torture, which should be explicitly recognized in domestic law and constantly restated in policies and statements by government officials. I will finally, I think I'm going to finish with this. The convention also indicates that the punishment for the crime of torture has to be proportional to the gravity of this crime. The convention requires state parties to penalize torture with punishments commensurate to the gravity of this heinous act. Additionally, it is an obligation under the convention to criminalize the commission and attempt to commit torture, complicity, and other forms of participation in torture, instigation, and incitement to commit torture, as well as acquiescence and consent by public officials to perpetrate torture. Beyond this, as a last final remark, we must keep in mind Article 15 of the convention that contains the exclusionary rule, which is extremely important in the structure of the convention. And we should also bear in mind that, that the convention requires the implementation of universal jurisdiction. We can talk a little bit more about it if necessary in its legislation. Finally, there should be no obstacles for investigation or prosecution of torture, including, for example, amnesties, immunities, statute of limitation, and other impediments that could be implemented or recognized in national law. I leave it there. Sarah, thank you very much for your attention.
Thank you, Mr. Diego Rodriguez. I would like to open the floor for questions to our panelists, but just if I may throw the first question to Mr. Diego, would you be kind enough to explain a little bit more for the benefit of our viewers and also our panelists, a little bit more about universal jurisdiction and how other states have complied with that? It's a part of the law on torture that we don't really talk about in Pakistan, and it's a pretty potent, it's my favorite principle really under the law. So if you would just talk about it a little bit more, please.
Yes, thank you very much. Sarah, well, I think it's very important to mention that this is an explicit provision under the convention. It's a very important provision in the sense that the convention makes emphasis that this requirement, which is an obligation to reflects the global concern that the community of nations place in confronting this heinous crime, so that alleged offenders have no safe haven in any place around the world. So I think it should be mentioned, first of all, that this is one of the few conventions that explicitly, Human Rights Convention explicitly recognizes this principle, which basically makes an emphasis of the importance that universal jurisdiction and the fight against impunity for perpetrators of torture has under the convention. There is no safe haven, either in the domestic jurisdiction of the state or beyond. The international community of nations has articulated a convention that encompasses literally at this point more than 170 countries around the world, seeking to avoid those perpetrators having any safe place they could flee after committing this particular crime. Indeed, many countries have implemented it, and I should note on that aspect that not only in the criminal aspect, that it has a collateral corollary that is linked directly with Article 14 of the Convention, the obligation to provide redress to victims. So it has also this double dimension, not only prosecution and punishment of the perpetrators, but redress to victims that is also extraterritorial, that has a very broad scope and requires the victims of torture to be also beneficiaries of redress and specifically rehabilitation by all countries under the convention. And this is a very, very special provision. We also could talk a lot about it, but I'll leave it there. Thank you very much, Sarah.
Thank you. Just for the benefit, just to reiterate, basically what it means is that if you're a law enforcement official or a public official in any country, country A, let's say, and you commit an act of torture, I mean, you're not tried or sentenced in your own country, and then you happen to go on vacation with your kids or your family to Switzerland, let's say, or some other country, and you can be held to account under the convention, under the universal jurisdiction rule. It's not as simple as that, but largely speaking, it means if you commit an act of torture as a public official, you are not given a safe haven anywhere. You can be tried and held accountable, and your victims will have a right of redress anywhere in the world, which is truly extraordinary in terms of the CAT Convention. My next question goes to Senator Faratullah Babar. Sir, when we talk about Pakistan's journey since 2010 to bring ourselves more in line with the obligations under the Convention Against Torture, and as Mr. Rodriguez pointed out, that the primary obligation is to specifically criminalize torture. You, sir, are the only person that was, drafted a bill, and actually it was passed by the Senate. Is there anything you can tell us about that bill and the journey of that bill? Why did you introduce it? How did you get it passed by the Senate? Why did it lapse? And what we can learn from the lessons of that bill to ensure that we are able to pass a successful legislation through the House and the lower and the upper house to criminalize torture.
Thank you very much, Sarah. Can you hear me? Is it audible? And I'm asking this because I'm very poor in the use of technological gadgets, and I wanted to be sure that you can see me as well as you can hear me. Good to know this. First of all, I would like to compliment Sarah, you, the Justice Project of Pakistan, and the World Organization Against Torture for launching this very important study that we are talking about today. I would also like to share with you, of course, my experiences and why the anti-torture bill has still not been able to clear all the stages. But I want to make one point before I comment on that, is that in Pakistan, torture in custody, in police stations is very rampant, is not uncommon. Even today, the newspapers have reported of the death of a 14-year-old child in police custody in Peshawar. And unfortunately, whenever such an incident happens, our response is standard. The response is the chief minister or the prime minister will condemn, the police chief will condemn, promises are made, that investigations will be made, and that we are going to introduce police reforms, regardless of which government is in power. But this is the standard response. In spite of all this, torture takes place. As you pointed out, that Pakistan has already signed the Convention Against Torture. We first signed that Convention Against Torture, and then we also ratified Convention Against Torture. It is now almost more than a decade that we signed and ratified Convention Against Torture. The foremost requirement of the government and the state of Pakistan was, after signing the CAT, to make domestic legislation to, number one, make a definition of what torture is. And the definition of torture must be in line with the United Nations definition of torture, and then how to criminalize that. It is now 10 years, but the law has not been passed. We made an attempt, and the attempt was made in 2014. Taking cue from this, that after having signed and ratified CAT, we must make the law. It was a private member bill, and I happened to be the mover of that bill. That bill was passed by the Senate on the 2nd March 2015, unanimously. It was one of those private member bill that was passed unanimously. That means all the provinces of Pakistan, all the political parties of Pakistan had joined hands in agreeing to that bill that we must have. It was, and before it was passed by the Senate in March 2015, 2 months before that, it was endorsed by the Senate Committee on Interior. It was endorsed by the Senate Committee on the Law and Justice. So that means the government and the government relevant ministries endorsed it. The whole of the Senate endorsed it. Under our law-making procedure, if a law is initiated and passed in one house, it has to go to the other house also. Ordinarily, laws enacting is initiated in the National Assembly. It also happens in the Senate. So this particular bill then had to go to the National Assembly. Interestingly, 2nd March 2015 is that day in the parliamentary history of Pakistan when not only a private member bill against torture was passed, but 2 other important private member bills were also passed on that day by the Senate. And there were anti-rape legislation and anti-honor killing legislation. All the 3 laws, private member bills, they were passed by the Senate, so they went to the National Assembly. Now in the National Assembly, it had to be taken up in a specified period of time in 90 days. It was not taken up in 90 days. Therefore, a motion was moved in the Senate saying that we want that since it has not been taken up by the National Assembly, we want all these 3 bills, the anti-honor, the anti-rape, and the anti-torture bill, to be referred to the joint session of the Parliament. Now, they were referred to the joint session of the Parliament, or at least we believe that they were referred to the joint session of the Parliament. And then in 2016, the anti-rape and the anti-honor killing bills did come up before the joint session. And after give and take and discussion among the parties and with the government and all this and that, those 2 bills were passed. Somehow this bill did not come. It should have come in the joint session. I have still not been able to figure out as to what happened, why it did not come. At that time, we were informally told that, well, it will come up in the joint session, if not now, next time, if not the next one, then, but it will come up. We said, okay. Then my term in the Senate ended in March 2018. Between 2017, when the anti-rape and anti-honor killing bills were passed, and now several joint sessions have been held, at least I think 4 or 5, but this bill has not come up. I don't know why. And it has not only come up, it has not only been not passed, it has not even come up before the joint session. The present government, I must say with great respect to all the people in the government, had promised in its manifesto that in the first month of its taking over, it will introduce a legislation. Then the Honorable Minister for Human Rights told us that the bill is almost ready and that we are going to get the approval of the cabinet and it will soon be done. We have Mangi Saab from the Human Rights Commission, the Human Rights Ministry. I'm sure he will enlighten us more on this. He has done commendable work on these issues, but he too has not been able to, he has not succeeded in doing anything about this because I think the issues are deeper, the issues are greater. Now, this present government now has been in office for the last 30 months, but we have not been able to see what the bill is, whether it has been presented to the cabinet or not. We are waiting for it, but it has not come up. Why it has not come up? I can only make a guess. And the guess is that in the torture of the citizens, a large number of cases belong to the internment centers in the tribal areas and in Khyber Pakhtunkhwa, which are military run and military controlled. And it is my suspicion, it is my hunch that perhaps our powerful security institutions do not want an anti-torture bill to be passed anytime soon. Because I would like to share this with you, that I thought that probably the government is not going to take up the bill because that was a private member bill. We offered to the government that, all right, since that bill was passed by the Senate, the government should take that bill, own that bill, delete the name of the private mover, and let it be a government bill. In spite of this generous offer to the government, it has not been done, in spite of the commitments of the Honorable Minister for Human Rights. And I have no doubt that the Honorable Minister is deeply committed to introduce this kind of legislation. But what is that is preventing her and is preventing the government? My suspicion is that the security establishment of Pakistan, the all-powerful establishment of Pakistan, does not want such kind of legislation, because then they will be on the spot, the internment center will be on the spot. And if you recall, in October 2019, about 18 months ago, the Peshawar High Court struck down all the convictions by the military courts against those who were detained in the internment centers. And the reason was the court observed that the confessions were obtained under torture. And I think that is the basic reason. So all now in the parliament, and I think also in the government side, we collectively, all the political parties, should address this aspect of the issue as to identify as to what are the forces, who are the elements obstructing it, and then to enter into dialogue, negotiation with them, to address their concerns also, but not to leave the matter hanging in the air as it is at present. Thank you.
Thank you, Babar Sahib. You took the words out of my mouth. I think, and before we go to Mangi Sahib, because you asked the next questions as well, I think the issue from an organization that has worked on this issue as well, not as long as you, sir, but the frustration is the same, right? If there are concerns, if there are hindrances, which might be for valid concerns, they can only be addressed when things are brought in a negotiation. Let's talk about it. Let's walk through it. And I think, unfortunately, in Pakistan, we work in silos, and there's very little collective action, which can perhaps, assuage fears and actually get the ball rolling. With this, Mr. Mangi has been sitting in the belly of the beast, the Human Rights Ministry, since 2001. And I think he has a lot more insight as a very senior bureaucrat into the workings of the government. Sir, what can you advise us? There's two new bills. Well, there's the government's bill and there's an opposition bill as well on torture again. That's been presented before the Senate and it's been passed by the functional committee. What is your advice to how we can be successful, both the government, the opposition? How can Pakistan be successful in actualizing what every government since 2000, since we've signed the bill, what every government has made? We've had 3 governments since then, right? And every single one of them have made a public commitment that they will criminalize it. So as an internal bureaucrat, what can we gain from your experience? How do we get this right?
Thank you, Sarah. Thank you, panelists. Good afternoon also. Let me say that there have been some of issues. And this torture bill we drafted in 2013, if you remember, the leading member was the Justice Nasir Aslam Zahid. The first bill we drafted. And since then, this was in the process. And when Babar Saab introduced his bill, then we supported that bill. On the analogy of that, if the government bill is not so quick, so the Babar Saab's bill will be through and we will take it up and supported that. But unfortunately, that has not happened. During last 2 weeks, we had a meeting with Ministry of Interior. My secretary, myself, Secretary Interior and his team to sort out issues because in terms of jurisdiction in Pakistan under the rules of business, this torture issue came under the Ministry of Interior's rules of business. So, and my minister as well informed the Prime Minister in the cabinet. Not this bill, but also criminalizing enforced disappearances. She, in a way, not suggested, but complained to the Prime Minister. And as a result of that, we had 2 meetings, one at secretary level in the Interior Ministry and another meeting at the minister's level wherein Law Minister, wherein Commerce Minister, my minister and Interior officials participated. And they have undertaken that they will expedite such things, and the Law Ministry would possibly wait within short span of time so as to be able to introduce the bill in the Parliament. So we have a good hope and news that maybe in few weeks' time, that bill will be weighted by the Law Ministry. So that is only the impediment now left. And
thank you, Mr. Mangi. May I ask a follow-up question? So previously, the hold-up, and this is just for the benefit of people like me and other organizations that work on this issue so that we learn from your experience. So previously, if I understand you correctly, the hold-up was really about what now? What makes you hopeful now versus before when the minister also promised? Do you think that there were hurdles then that you've cleared now that should give us more hope for, this might be the final home stretch?
I think as concerned with the...
Is there anything we can do to help? As in we as the public, as in we as society, as in we as parliamentarians, what help can we give you to make this dream a reality?
Definitely. We had a lot of consultations previously on this subject matter. And whenever the Law Ministry and Interior Ministry particularly, they invite comments from the provincial governments. So some of the provincial governments are objecting that how we will be doing if we make punishable this, so how to deal with the harsh criminals. But now provincial governments are in agreement with us. That was the issue and long time consuming element. And now Interior will hopefully give us NOC and the Law Ministry will wait the bill, because it has been time and again. I think last 10 days we had a meeting of the ministers on such issues. So hopefully, I don't see now any more impediment in a way to have this legislation introduced in the parliament, because it has been sensitized to the Prime Minister, and Prime Minister has agreement with our ministers' suggestion that it should be done immediately.
That's just such wonderful news to hear, Mr. Mangi. Senator Babar, would you like to ask something?
Yeah, yes, Sarah, you asked a very good question, I think, when you said that how people like you, the Justice Project Pakistan, they can help in the matter.
Yeah.
What Mangi Saab has stated, I hope that his optimism is right and the bill is cleared by the Interior and by Law and Justice, etc. However, the way in which people like you can help, I think, is that if you hold a discussion in which you invite all the political parties, the government, and also the security establishment, and the discussion should be focused on the topic that anti-torture legislation, identifying the elephant in the room, as to what is the elephant in the room, that in spite of, it is not the question of just one government.
Yeah.
When the bill was passed in 2015, it was a different government. And when the bill was introduced by me, it was our government. So, I mean, it is not the question of this government or the previous one or the one before the previous one. It is a fundamental issue. And the fundamental issue is to identify the elephant in the room. You can just put a question in that seminar, and that should be addressed only one question as to what has happened, that Pakistan signed and ratified. It is more than a decade. It has not been done. And then let all this be a rundown be given as what I have given to you. And then I would suggest that your report, you should send it to the parliament. Let there be a discussion in the parliament, but both sides taking part in the discussion, because otherwise, if we do not call a spade and we do not identify publicly the elephant in the room, the elephant will not come to talk with us. We have to identify and then persuade him. If you have reservations, please come and talk with us and we will address your reservation. And why I say this, that you know the elephant in the room I have identified and I have no doubt in my mind. For example, internment centers where there are reports of torture, which have been taken note of by the High Court. It suspended and reversed all the military court verdicts. As a parliamentarian, I wanted to visit the internment centers. We were denied. Members of the parliament could not visit the internment centers. And you were there, Sarah Bilal, when that report on the Faisalabad torture thing, which you had prepared in consultation with the NCHR, and the chairman of the NCHR said that he wanted to visit the detention center of NAB, and that NAB had disallowed him. And your report stated, it was your report, that a question pertaining to the anti-narcotics force, they even refused to answer the question. So an anti-narcotics force is a military-led establishment. And you go and visit the ordinary jail. I visited Haripur jail to visit Mohsin Dawar and the other, I forget his name now, but I went there some time back to visit them. And even the civilian jail, the military men were there and they were controlling, they were calling the shots. I have seen it myself. So if in the civilian jail this is happening, what to speak of the military-run internment centers? Therefore, let us find a way to initiate an honest dialogue on this issue without incrimination, without point scoring, without laying the blame on anybody. I have really no doubt in my mind that both Mangi Saab and his minister, the honorable minister, they genuinely want some legislation to be passed. Probably the Prime Minister also wants. My party definitely wants. PMLN also wanted. Why? Where they are stuck? Let us have an honest appraisal. Unless we have an honest appraisal, we will be moving in circles and reaching nowhere. So my suggestion to you, Sarah, is that your next meeting should be an honest effort to identify the elephant in the room. Thank you.
Thank you, sir. You always give us very good ideas about how to proceed and to continue in this fight. Might I ask, this question is for Dr. Nicole as well as Mr. Diego. What impact would a country who's going into their second review, like Pakistan next year, before the CAT committee, and has pledged, for example, Pakistan just won a seat at the Human Rights Council, and in their voluntary pledge, once again, they reiterated their commitment to passing this legislation. What impact would it have on Pakistan's CAT review, second CAT review, if they were able to pass the legislation? And are there examples that you can give us from the path that other countries have followed? We're not the first ones, we're not going to be the last ones, but perhaps we can learn from the journey of other countries. I'm sure legislation like this, the first of its kind, is a paradigm shift in the history of a country. So are there any lessons that we can learn from the experience of other countries along this journey that you can think of? Whoever wants to go first. Dr. Nicole, would you like to go first? Or Diego, would you like to go first? Go ahead, Dr. Nicole.
Thank you. I think having an anti-torture legislation in place would be an important step and something very important to report about before the CAT. I mean, Diego is in a better position to talk about this, but this is usually for a lot of countries. This has also been kind of an easy step to implement something that's very important for the CAT. To implement the convention, domestic legislation is important, and usually this is something that countries or many countries have done relatively easily. Of course, this is not the case for all the countries, and I do realize that for a lot of countries in the region, this has been difficult, and there were a lot of domestic discussions and also hurdles in many countries. We've seen in other countries, for instance, I work a lot on the Philippines. The Philippines, they have enacted a law in 2009, and they have a very comprehensive law. And of course, convictions do not follow automatically, but it allowed lawyers and human rights groups, it allowed them to represent victims and before court and bring perpetrators to court. We haven't, in no country have we seen that there were a lot of cases flooding to courts. No, it is still very difficult in many countries, but it is an important first step. Even in countries where torture is systemic, such as, for instance, Bangladesh, there are convictions under an anti-torture domestic law. It is not easy, but usually it is necessary that this is actually possible. As I've said before, torture perpetrators, they're not convicted under the regular criminal code provisions. So it is really important that countries have this type of legislation in place.
Thank you, Sarah. Yes. Well, simply to make a couple of comments in this regard. The first, that indeed, of course, and I don't have to tell you, a positive development such as the implementation of anti-torture legislation under the convention will be a very important step for the state and for any state that is reporting before the committee. The committee engages in the constructive dialogue, it's an interactive dialogue, and this will pave the way. It facilitates the conversation so that we can jointly begin to explore all the aspects that are, of course, reflected in this type of legislation in different countries. All countries, as you know, are different. The experiences can be helpful, but each country has its own particularity, its own dynamics. And in that sense, the conversation that we have with states is focused on the specifics of the particular country. So simply to say, yes, it's important, is that there will be recognition, as it always has been. If you see the concluding observations, for example, regarding any country, one of the first things that a committee does is to recognize precisely the steps that states have progressively taken in implementing, for example, anti-torture legislation and other very important legislation in their own jurisdictions. And this is, again, a very positive step that will help towards the conversation that we have during those 6 hours in the committee. Additionally, and simply to indicate that when you have also the benefit of impacting several venues, international fora at the same time, again, it increases the benefit of adopting, of creating this positive precedents. If you have a council pledge that will be reacted upon based on the legislation, of course, it multiplies the benefits on the diplomatic position of any state in the international venue. We are very deliberate in the case of the committee in engaging in the merits, in the conversation on the specific problems, and we look at the challenges. Of course, we understand the problems. Depending on the reality of each country, the obstacles are sometimes complex, and that's why we want to engage in a constructive dialogue to help the states navigate their own internal challenges. Again, that's for the state. We are there simply to collaborate and to contribute in that process. Thank you, Sarah.
Thank you so much. My final question is to everybody, actually, but starting with Mr. Mangi. Mr. Mangi, since you have been tasked, I'm pretty sure, with writing Pakistan's second periodic, with second state report, I'm just wondering if we don't get the bill in time. There were some other concluding observations from the last time that the state was reviewed in terms of data on redress and accountability. What do you think we're going to say? Because there was an NCHR report based on our data that came out in the last cycle, after the last committee. And they also found that from that data set that had been produced before the committee, many years onwards, there was a lack of accountability. Are there any other efforts that the provinces or the federal government have undertaken? I mean, the bill can be like a bigger goal that can count towards fulfilling some of the concluding observations of the committee that makes us look good.
Sarah, as I mentioned, that we had a meeting with Ministry of Interior. Besides this bill issue, we also flagged data issue. Because essentially the data has to come from certain police systems and agencies also. And they have formed core group, myself representing Ministry of Human Rights, and also one of the additional secretary, Shalyani Saab, from the Ministry of Interior, to facilitate all the required data and all pending issue in terms of human rights issues, particularly for the reporting. So we have prepared, break up the recommendations precisely X, Y, Z, what we are requiring to fit in the report with regard to committee's concerns and concluding observations. So hopefully we have made sensitize the Ministry of Interior, partial government departments, and we ourselves are evolving human rights management information system. So KP has already, we are facilitating other provinces in managing human rights information system. So hopefully, till the time we submit the report, we will be having more than 60% qualified data. In terms of issues, as I said, that because of minister's commitment and speaking against even his own colleagues in the cabinet, the Prime Minister has been very sensitized and has issued instructions to various ministries to expedite this one. So I'm optimistic. I'm
always optimistic, sir.
Yes.
My final question, thank you so much, Mr. Mangi. I really hope our country shines in the next CAT review.
Hopefully.
My final question, because I know Mr. Diego has to leave, is also to Senator Faratullah Babar. And Mr. Mangi, feel free to correct me if I'm wrong here, but if policing is also a provincial function, it's one of those things that's federal but also provincial. Why are we not passing a provincial law to criminalize torture? Why are the provinces waiting for the federation? Can't we do it at a provincial level?
Yes, you are right. But since the crime is subject the state through federal government and the provinces, they have concurrent jurisdiction. They can amend even PPC, CRPC, and they can introduce any law. But since we are, for instance, we did, in case of juvenile justice system, revise the law, and now we are doing a couple of other legislation wherein, again, the provinces can legislate. For instance, we are making law on forced conversions. So the federal government is doing that, but definitely provinces would be involved. So it is better to have legislation essentially changing your criminal justice system for such offenses. So we are optimistic. Hopefully we will do it.
Senator Babar, would you like to add something? Perhaps PPP can take the mantle and do it and save Pakistan's honor before the CAT committee. Maybe if your province can pass it.
Thank you, Sarah. I think that the anti-torture legislation is part of Pakistan's commitment at the international level. And commitments made at the international level and legislation made in pursuance of honoring those commitments falls under the federal thing. So to that extent, it is the federal subject. However, I think, I'm not sure, but I'll now, since you have sensitized me to this subject, I think, yes, a study should be made if the provinces can do also. And I tell you, I will very strongly urge the provincial government of Sindh to give it a thought and to make a beginning. But I'm not sure whether under the constitutional dispensation of the division of legislation making, whether it comes under the province or not. But I think it should be coming also to some extent under the province. So I think it's a good point that you have made, although fundamentally, since it relates to our commitment to the international community, it should be done also by the federal government. One point that I want to make, we should not be hesitant to take even small steps. To say that overnight it will be resolved, it is very difficult. For the last 10 years, it has not done. But what can be done now and immediately what can be done is the revival of the National Commission on Human Rights. Yes. That commission is lying moribund.
Sorry, Senator Babar, Mr. Rodriguez has to leave because he was joining earlier. Thank you so much. It's been an honor.
Thank you very much to everyone. It's been my honor, and again to commend you for the efforts and count. I'm sure with all the colleagues in the committee and academia and anything we can do to help you. Thank you very much again.
Thank you.
A pleasure.
Thank you.
I'm sorry.
Okay. See you next year.
Okay.
Please continue, Senator Babar. Please.
Okay. So number one, I said that, the National Commission on Human Rights is lying moribund, is closed almost. And the NCHR was doing a commendable job. Even with respect to the torture also, they prepared a report on the torture. They tried to submit it for the UPR time, etc., etc. So I think that the National Commission on Human Rights should be activated. The National Commission on the Status of Women, that also needs to be activated, because when these two statutory institutions are activated, it will raise voice, among other things, also against the torture which is prevalent. And this is something that is doable, it should have been done. And if it has not been done for the last over 1 year, it should be done right away. The second thing that I would again like to urge you to give it a thought. Last time it was the NCHR which wanted to go at the time of the Universal Periodic Review and submit its report. But I believe that at the time of the UPR, when the state narrative is presented, I think the rules permit also private sector NGOs also to present their point of view. And when you hold that kind of seminar and discussion, which I suggested to you earlier, to identify elephant in the room, I think that will be the best occasion for an institution like you to take that report to the UPR and let there be some frank discussion at that level. So I think it can be done provided there is political will. And I think that many parties have got that political will, but they are obstructed because, as I identified to you, the elephant in the room. Therefore, Sarah Bilal, in your next engagements, focus on the elephant in the room, and only then we can proceed further. I'm sorry if I've used a kind of language which some people may not like, but there is no other way to express this to you, because I've seen it from close quarters. I have seen it so closely.
I point completely taken, but my retort to you would be, if the elephant in the room comes, then will there be a true spirit of compromise? Because it might require, and you and I have had conversations about this in the past, a utilitarian paradigm shift might come in stages. So
it might require
a paranoid elephant. Maybe, let's deal with the police first.
Yeah, I have not spoken with the security people, but I think what would be in their mind is this, that in the anti-torture bill, no explanation whether you are in a state of war, whether there is political instability, whether it was a command by the superior, nothing can justify, nothing can be accepted as defense for the crime of torture. Therefore, it is possible that the security establishment has this thing in mind, and they might say, oh, we are in a state of war, and you have excluded the state of war as a defense. We can talk with them.
But we have a good, we have a very good example that was already in legislation that actually worked out quite well. So if you look at the NCHR Act, the statutory provision that allowed, that was the forming of the NCHR, they have an added level of, an added layer when dealing with the security establishment. So the NCHR had wide powers to go into any facility or to investigate anything. But structurally in the law, if there was something relating to the establishment, there was an added layer of vetting before the NCHR could kind of go into it. So it was more in a spirit of compromise. I frankly don't see why that formula cannot work in legislation to do with torture. If what you are saying is indeed the truth, sir, that there are concerns from the establishment, then a paradigm shift would involve, as a first step, we have a successful statute where you had an independent state body that had wide powers to investigate, but within the structure of that act, there was an added layer as a deference or as a, that allowed for it was just an added layer. That's a good workable compromise. And we had the NCHR serve out an entire term without ruffling that many feathers. So perhaps that's something, that can be looked into. Perhaps that's a compromise that might get the elephant to agree. I have no idea. I've never seen the elephant. I've never ever spoken to them, but I'm fascinated by them. And I really do hope, I agree with you 1,000%, sir, that if we are going to, as a society, take this step, we have to keep in mind all of the stakeholders. And that includes elephants and giraffes and zebras and you name it. And we cannot ever hope to have a discussion. But maybe Mangi Saab can do it with the MOI, and then we'll erect a statue of you, Mangi Saab, if you manage to do
that. Yes, we are doing it. Definitely, and with our sincere commitment. With regard to appointment of chairperson NCHR and chairperson NCSW, under the law, opposition leader has to be consulted so as to forward 3 names out of the list we provided to the leader of the opposition. One is more than 1 year in case of NCSW, and the NCHR list, I think more than 3 months. So you can facilitate us by lobbying with opposition leader that at least you may select your name, whatever the name you may select, and forward us so that we may forward it to the parliamentary committee. So the government is not at default in both of the cases, in chairperson NCSW and also NCHR chairperson and members. So once they are finalizing, we can send to the parliamentary committee. That is also there, and then the commission, both the commissions would be fine in working. Government has no problem on this issue. Only thing is,
I think it's unfortunate that there is such discord, and I don't think a lot has been able, good stuff has been able to be achieved because of the discord. I think, Senator Babar, that before we have the consultation that you've mentioned, I think we should have group therapy with all of the political parties and the government. Just so that we can all get along and start from a fresh slate. But that's why I'm not in politics and you are, because I have very bad ideas about politics. And I'm sure you're way better at this.
I really don't know, but I was, my sense was that the names which were sent to the opposition leader, he has already given his opinion. This was my sense, I don't know. But now Mangi Saab says, so he must be right because he deals with the subject. But my sense was that the opposition leader had communicated the names, but I have to check on that now because
perhaps we can get that moving.
In case of NCSW, we sent 13 reminders to the leader of the opposition to please give us some name so as to forward to the parliamentary committee. And in terms of NCHR, we sent all the names as directed by the Prime Minister for all members and the chairperson. I asked his director staff requesting to do that, and that is in the best interest of the country. So, but no clue yet.
Well, thank you for pointing it out. Thank you for pointing it out because I can then speak with the opposition leader also, if not directly through my own party, as to what has happened. Because my sense was that it had been done, but you are the right person to say that no, it has not been done.
So even the Supreme Court Chief Justice has taken suo motu on both of the commission. We responded to the Supreme Court, and in terms of NCHR, he has directed that file a suit in the High Court or not responding governments. So this is the direction from the Chief Justice of Pakistan on the issue of NCHR.
I hope that the issue can be resolved soon, Dr. Babar. I think if you and Mangi Saab, as you have such a good relationship and you're both human rights oriented, I'm pretty sure the two of you can actually manage to get this done. But I think we've taken a lot of time. I would just like to thank all of the panelists. I could spend 2 more hours listening to all of you because I have so much respect for the people in this virtual room right now. I know where all our north lies, and I know that if ever this country is going to fulfill its promise and pass a law, it's going to be with the people that have been on this panel. So I wish you all the luck from the bottom of my heart, and thank you, Dr. Burley, for your support, and we'll see you next time, hopefully with a lot better news to celebrate. Thank you so much.
Thank you.
Thank you. Thank you.
Thank you very much.
Chalo, bache.